Peter Underwood. This is news from the water. New terms and conditions create a dual licence system for the first time. We now have the latest version of Canal and River Trust's terms and conditions for boaters. Why is that important? Well, the current changes overturn a decision made by Parliament back in 1995 to deny what was then British Waterways permission to create a separate continuous cruiser licence, which would have opened up the possibility of treating and charging one group of boaters differently from others. And at the same time, boaters with a mooring now face the possibility of being thrown off CRT waters if they stick around in one area for too long. Another change to the simple rules set out in the 1995 law. The changes represent the latest efforts of the Trust's big and expensive legal department to replace the existing law with commercial contracts that give CRT powers that the law denies them. It seems likely that the changes will be challenged in the courts by both the National Association of Boat Owners and the National Bargee Travellers Association. The NBTA has been quick to point out that one of the most insidious and significant changes, which was not even included in the consultation, is that the new terms and conditions separate the standard canal and river licence, which should apply to boats licensed both with and without a home mooring, into two new categories. A so-called pleasure boat licence, which must have a home mooring, and a continuous cruiser licence. Now the NBTA says this is in direct contradiction of the definitions set out in the 1995 British Waterways Act. It goes on to say,
"It is obvious where CRT is going with this sweeping reclassification. The separation of the standard canal and river licence into two categories would make it easier for CRT to charge a higher fee for a so-called continuous cruiser licence, something which was threatened and consulted on several times by British Waterways, most recently in 2008, but was dropped each time following opposition."
Now, the 1995 British Waterways Act establishes a single boat licence, which should be granted if
the board are satisfied that a mooring, or other place where the vessel can reasonably be kept and may lawfully be left, will be available for the vessel, whether on an inland waterway or elsewhere, or the applicant for the relevant consent satisfies the board that the vessel to which the application relates will be used bona fide for navigation throughout the period for which the consent is valid, without remaining continuously in any one place for more than 14 days, or such longer period as is reasonable in the circumstances.
These extra rules and changes imposed in the latest terms and conditions have the potential to impact boaters of all persuasions, those with and without a mooring. However, the Trust bases its claim to be able to go beyond the 1995 law on the obscure section 43(3) of a piece of general enabling legislation called the Transport Act 1962, which says,
"The British Waterways Board and Canal and River Trust shall each have power to demand, take and recover or waive such charges for their services and facilities, and to make the use of those services and facilities subject to such terms and conditions as they think fit."
CRT claims the changes proposed in the most recent consultation are in line with what this Act allows. It says,
"It is acceptable to use similar wording to other legislation and bylaws. Doing so means that the boater can find more of their obligations within the terms and conditions document, which may help increase understanding and encourage better boating behaviour. It also allows the Trust an alternative method of resolution to bylaw or criminal prosecution in the case of non-compliance."
Numerically, most boaters will be affected by the new terms and conditions regarding boats with a home mooring, meaning that every time they leave their mooring they must be on a journey and can't simply hang around an area they like, moving every 14 days. The suggestion is that this is to deal with so-called ghost moorings, where boaters have a legitimate mooring but rarely return to it, choosing instead to stay in a different area without necessarily travelling the 20-mile minimum range imposed on boaters who declare they don't have a home mooring. But there's no evidence to show that this is really a problem at all. CRT claims
The condition also allows us to manage times when a home mooring, sometimes in an unrelated area to where the boat is on the water, is purchased to allow the boater to remain in a small area without returning to the home mooring. In those circumstances, the mooring is obtained and used disingenuously and doesn't provide fair access to moorings in certain areas.
As one NABO member pointed out, CRT has been asked numerous times to quantify the scale of the problem they're apparently trying to address. He said,
"They tried to tackle this at the last consultation with the no shuffling clause. Now you must continuously cruise. They still don't know the scale of the problem. I was told it was a small number, but needed addressing. So, changing the terms of 30,000 boaters to tackle around 1% seems strange, when CRT are happy to consider 5% unlicensed boats as an acceptable level."
Another change in the T's and C's gives CRT's greater part if their staff are verbally attacked. Perfectly reasonable in light of the recent towpath killing of a member of staff, except that CRT assumes the power of judge and jury. As the same NABO member pointed out,
the huge majority will carry on as normal, assuming none of these changes apply to them. Until, of course, they have, for example, an unwitnessed, alleged argument with a volunteer lockkeeper, with CRT now the only arbitrator, and lose their license. Or spend a month in the summer on their favorite 10-mile stretch, rarely sighted despite moving every 14 days, and lose their licenses not on a genuine cruise.
And there lies the core of the problem, as breaches of these terms and conditions, in CRT's view at least, give them powers to remove a boat licence, powers that don't really exist in the legislation. The Trust insists that it would do the right thing.
Unless it was a serious breach, we would contact the boater, point out the issue, and explain how the situation could be fixed. If the problem is fixed and not repeated, that would be the end of the matter. Where the problem is not fixed or is repeated, we may suspend, restrict, and/or terminate the license.
Anyone faced with losing their licence because they're claimed to be in breach of these terms and conditions will find, as CRT admits, there is no specific appeals process for the termination process. It claims,
our regional teams will usually attempt to resolve the incident or incidents that lead to a license termination. At the point of suspension and investigation or termination, members of our National Boat License Support Team, legal team and, where relevant, our welfare officer will become involved. They will review the case and provide a degree of assurance to the process and ensure impartiality. Should termination of the license still occur, in the case of a boat that is lived on, the case will be heard before a judge, as we will obtain a court order before removing such boats. In non-liveaboard cases, there is an option for the boater involved to approach the court themselves. As the boat license forms a contract between the trust and the license holder, we also have the Waterways Ombudsman as our route of alternative dispute resolution, and an affected boater can refer the matter to the Ombudsman, having gone through our internal complaints process.
Well, that's all right then, except of course that nobody actually trusts an ombudsman paid by the trust. And the trust is not quite so draconian when it comes to setting out its own obligations. It doesn't agree to provide a working waterway even.
The license fee grants permission for the licensed boat to be present on trust-owned or managed waterways. The license is not a guarantee of access or availability of the waterway. Refunds of license fees will not be made for closures.
And if your holiday is ruined or your boat capsized due to a breach,
we exclude any liability for any damages arising from the closure of the waterway, save for any damages arising from personal injury or death caused by our negligence.
The immediate response from NABO stalwart and campaigner Simon Robbins was that the interesting thing about a lot of these terms and conditions changes are that there's a great deal of bluster and what he bluntly called willy waving on CRT's part. The fact is, says Simon, that if and when so many of these things are actually put to the test by a competent boater with proper legal advice and get close to a court judgment or similar, CRT nearly always step back from the legal brink when it actually becomes apparent that they're about to get a precedent set against them. He says they rely on a bullying attitude and the hope that people don't have the time or resources to challenge them strongly enough. And he says the thing is, they too often get away with it. Well, they may not this time. The National Bargee Travellers Association has already said it will continue the legal challenge to the new boat licence terms and conditions. Its statement said,
CRT appears to have treated the consultation as a majority voting exercise, using the number of favourable responses submitted as justification for its original proposals, and ignoring the detailed objections regarding the proposals and the conduct of the consultation from many individuals and organisations. In addition, there are a number of changes that CRT has included in the final version of the revised terms and conditions which were not included in the consultation, so boaters have not had an opportunity to comment or even to assimilate the changes.
So the NBTA is in no doubt that this is another attempt by CRT to divide boaters into different groups and use financial penalties as a way of driving boaters who live on board out of popular areas like the Kent Haven and Greater London. Looking at the proposals to insist boaters with a mooring have to be on a journey, the NBTA also quoted the judgment in Canal and River Trust versus Geoffrey Douglas Mayers, in which the judge found that
a boat which has a home mooring is not required to be bona fide used for navigation throughout the period of the licence, but neither is it required to ever use its home mooring. The British Waterways Act 1995 requires that the mooring is available. It does not say it must be used. The guidelines also have this effect. The boat is still subject to the restriction that it must not stay in the same place for more than 14 days. But there is nothing to stop it being shuffled between two locations quite close together, provided they are far enough apart to constitute different places.
Difficult to square that legal opinion with the new terms and conditions, of course. The MBTA contrasts that with the new section 5.1 of the terms and conditions, which insists a boater must travel on a journey when they're away from their home mooring. It also goes on to say the journey should be a genuine journey. It should start and end at the home mooring, and it can't contain short repeated movement in a small part of the waterway for an extended period. Now, Canal and River Trust may hope the new terms and conditions are a done deal, and their grip on the lives of boaters has been strengthened. I suspect there are court battles to come. That's it for this week, and just quickly a big thank you to all those who wished me well for my operation a week or so ago. It all seems to have gone pretty well. I'm still standing, as they say.